The Fair Housing Act makes it unlawful for a housing provider to refuse to make a reasonable accommodation that a person with a disability may need in order to have equal opportunity to enjoy and use a dwelling. One of the more common requests is for a reasonable accommodation to a pet or no animal policy to allow individuals with disabilities to keep and use assistance animals. Assistance animals are not pets. As they are not pets, housing providers may not treat assistance animals as pets under the lease or other rules and policies. The housing provider may not exclude or charge a pet fee or deposit for assistance animals, but they may charge for damage caused by the animal. The housing provider also may not limit the size or breed of the dog, but can impose limits based on the specific animal's conduct if it poses a threat. The housing provider can deny a reasonable accommodation if the threat posed by that specific animal cannot be reasonably mitigated by actions you take to control the animal, such as keeping it locked up away from others. There are generally two types of assistance animals: service animals and support animals, which are other animals that do work, perform tasks, provide assistance and/or therapeutic emotional support for individuals with disabilities. Now, under the ADA, the Americans with Disabilities Act, a service animal is defined as a dog that is individually trained to do work or perform tasks for a benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. The tasks that the service animal performs must be directly related to the individual's disability. Service animals are protected under the Americans with Disabilities Act in addition to the FHA. For service animals, housing providers should first determine whether the animal is a dog and whether it is readily apparent that it is trained to do work or perform tasks for the benefit of an individual with a disability, such as leading someone with vision impairments, pulling a wheelchair, or providing stability or balance assistance to someone with an observable mobility disability. If it is not readily apparent, the housing provider should limit itself to two questions. 1, is the animal required because of the disability? And 2, what work or task has the animal been trained to perform? As long as the dog has been trained to perform at least one task which is helpful to the disability, other than emotional support, it should be considered a service animal. For service animals, the provider should not ask for any specifics regarding the disability or ask for documentation. If the animal is not a dog or does not perform any tasks other than providing emotional support, it is not a service animal under the Americans with Disabilities Act. However, it may still be a support animal or other sort of assistance animal protected by the FHA. Reasonable accommodation requests. The housing provider does not have to make any accommodations unless you or someone on your behalf actually requests a reasonable accommodation. There is no specific language required for making a reasonable accommodation request, nor does it have to be in writing. However, it is a good idea to put it in writing and specifically state that it is a reasonable accommodation request in case there are any later disputes. If the disability is readily observable, or they already have reason to know or believe that you have a disability, such as being aware that your income comes from disability benefits, they cannot ask for proof of the disability. If it is not observable, they can ask for documentation of the disability, but they are not entitled to know the diagnosis. Additionally, the housing provider can request information that supports the disability-related need for the animal. There is no specific form for this documentation, and housing providers cannot require a specific form, but the best documentation to support a reasonable accommodation request is a letter from your healthcare provider that identifies you by name, explains their professional relationship with you, and specifies the type of animal for which the reasonable accommodation is sought. It should also specify the general type of disability, whether it's physical or mental, whether that disability substantially impairs a major life activity or bodily function, and whether the patient needs the animal because it does work or performs a task that benefits the patient due to the disability, or because it provides therapeutic emotional support to alleviate a symptom or effect of the disability. If the animal is not a common household animal, you will have a substantial burden of proving that the specific animal or type of animal is necessary. Common household animals include a dog, cat, small bird, rabbit, hamster, gerbil, other rodent, fish, turtle, or other small domesticated animal that is traditionally kept in the home. They do not include reptiles other than turtles, or barnyard animals, monkeys, kangaroos, and other non-domesticated animals. If the animal is not a common household animal, you should ask your healthcare provider to explain in their letter why that specific animal or type of animal is needed, as well as when they last consulted with you. If you are requesting a reasonable accommodation for more than one animal, you may need to demonstrate a disability-related need for multiple animals. This might include separate disability-related needs for each animal, such as them performing separate tasks, or multiple disabled people each requiring their own assistance animal. When you make your reasonable accommodation request and provide any requested documentation, the housing provider should provide a response within 10 days. If the reasonable accommodation request is denied, the housing provider should still engage in a good faith dialogue with you to resolve the issue. If they are denying it for insufficient documentation, they should discuss with you what more they need. They cannot request medical records or disclosure of the diagnosis or severity of the disability, nor can they require that the documentation be provided on specific forms. If they are denying it because it would impose a fundamental alteration to the nature of the provider's operations, or impose an undue financial and administrative burden, the housing provider should discuss whether an alternative accommodation might be effective in meeting your disability-related needs. We hope this information will enable you to understand and exercise your rights under the Fair Housing Act if you need a service or support animal.